Hello, and welcome to another presentation in the Archives Alive series at the Stonewall National Museum and Archives in Fort Lauderdale, Florida. I'm Dr. Harvey Abrams, and I'd like to start this talk in 1982. If you recall, Ronald Reagan was president, and we were all becoming increasingly alarmed by a new cancer, which seemed to affect only gay men. It was also the year that would change the life of Michael Hardwick, a young gay man who is the focus of my talk today. Little did he know when the year began that he would be involved in a court case that would make front-page headlines in newspapers across the country. In 1982, Hardwick was 24 years old and a bartender at The Cove, a neighborhood bar in Atlanta, Georgia. On the morning of July 5th, as he was leaving the bar and going home after a long night at work at the end of the July 4th holiday, he tossed an empty beer bottle into a receptacle outside the bar. Unbeknownst to Hardwick, the bar, known for its gay clientele, was being surveilled by police officers who wrote out a citation claiming that Hardwick was publicly drunk, a claim he vehemently denied. When Hardwick appeared in court on the day specified on the citation, he was told that the date the officer put down on the citation didn't match the date on the court's docket, that he would have to come back another day that week to resolve the matter, which he did. He paid a $50 fine, took the receipt, and went off to work, which should have ended the matter once and for all. But as history would have it, it didn't. Unfortunately, in this comedy of errors, the court's paperwork indicating he had paid his fine never caught up with the original citation notice, which gave the appearance that Michael Hardwick had skipped out on his court date, prompting the judge to issue a warrant for his arrest. And so one evening, the same officer who issued the public drinking citation went to Hardwick's apartment to serve him the arrest warrant. When he got there, he was let in by Hardwick's roommate, who walked back to the bedroom area to let Hardwick know that there was a police officer looking for him. The officer followed the roommate down the hallway and somehow was able to peer in through the door that was slightly ajar and observed two men having oral sex. He then burst into the room and announced to the men, "You are under arrest." Hardwick, suddenly finding a police officer in his bedroom, had the presence of mind to say, "Excuse me, but what are you doing in my bedroom?" The officer reportedly explained the arrest warrant and reminded Hardwick that he had warned him that if he didn't show up in court, he would come looking for him. Hardwick tried to explain that he had already been to court and had already paid the fine, but the officer, in no mood to listen, handcuffed the men to each other and took them to the police station, where he charged them with sodomy and put them in jail. At no time did the arrest warrant for Hardwick's alleged failure to appear in court charge ever come up again. As I continue to recount Michael Hardwick's story, I want you to keep in mind these questions. Did the state of Georgia, in this case, the police officer acting on behalf of the state of Georgia in 1982, have the right to arrest Michael Hardwick for engaging in oral sex with another man in the privacy of his own home? Or did the state of Georgia, by arresting him, violate his right to privacy as protected in the Constitution of the United States? The two men were in jail for a day when their case came up before the district attorney. Hardwick's companion was a man in his early 40s who was visiting Atlanta for the holiday. He had a wife and two kids back in North Carolina. He wept and begged the district attorney, "Please don't tell my wife, and I'll lose my teaching job." The district attorney was sympathetic, especially after he learned that Hardwick had already appeared in court and had paid his fine. Hardwick's companion pleaded guilty to a lesser charge and immediately split, undoubtedly happy to get the hell out of Georgia, his part in history completed. Michael Hardwick paid a fine of $50 for possession of marijuana, unaware that unlike his North Carolina companion, his role in history was about to begin. For as it happened, shortly following his arrest and release, Hardwick was contacted by lawyers from the ACLU, the American Civil Liberties Union, who had heard about his case and believed it was the perfect case to challenge the constitutionality of Georgia's sodomy law. But before I get to that, I think it's probably necessary to give a little background on sodomy. In 1982, Georgia, like many states, had laws called Sodomy Laws, which made oral and anal sex illegal, whether it involved two men, two women, or even if it involved a married husband and wife, and even if it was carried out in private. Sex between a human and an animal was also considered sodomy and was also illegal. Should a person be caught, tried, and found guilty of violating the sodomy laws, he or she would be a criminal for having sex and would be subject to a wide range of punishments, from fines to prison terms of up to 20 years, depending on the state in which it occurred. In some states, repeat offenders would be subject to life imprisonment. Sodomy laws were intended to restrict sex to vaginal intercourse between husband and wife for the purpose of producing an offspring, period. Getting back to Hardwick. With the ACLU urging him on, he found himself being pressed into a role he never bargained for. He was a young, tall, good-looking guy who, as a bartender, made up with lots of men and enjoyed the easy, carefree life. Nevertheless, after speaking with the ACLU attorneys, he came to realize that this was a moment of decision, a rare moment when he could make a difference. He also realized that although the recent charges against him had been dropped, what would prevent the police from arresting him again, or any other gay man or woman, for that matter, the next time they engaged in sex, even if done in private? Michael Hardwick, an unlikely man of the hour, rose to the occasion. With the ACLU branch behind him, he filed a lawsuit in Georgia District Court, asking to invalidate on constitutional grounds the Georgia sodomy statute, on which grounds he was arrested. So now, with this bit of background in mind, let me repeat the question I posed earlier. Did the state of Georgia have the right to arrest Michael Hardwick for having consensual sex with another adult male in the privacy of his own home, or did the state of Georgia violate his right to privacy as protected in the Constitution of the United States? Briefly, this is how Michael Hardwick's case unfolded. The ACLU filed a suit against the state of Georgia, which they lost on a procedural technicality. They then took his case to the U.S. Court of Appeals, where a panel of judges declared, after careful deliberation, that the Georgia sodomy statute had indeed violated Hardwick's fundamental rights because his homosexual activity was a private and intimate association that was beyond the reach of state regulation by reason of the Ninth Amendment and the Due Process Clause of the 14th Amendment. In short, the U.S. Appeals Court declared Georgia's sodomy law unconstitutional and therefore null and void. They won. A victory for sure, but a short-lived one. For it was now that Georgia's Attorney General, Michael Bowers, got into the act. Not content with the decision to let homosexuals have sex in the state of Georgia, not without the worry of getting arrested, he filed a petition in the United States Supreme Court to overrule the appeal court decision and defend the state of Georgia's right to arrest Michael Hardwick for having sex. Incredulously, his mean-spirited petition requesting a hearing was granted, and thus the case known in history as Bowers versus Hardwick was born. It took 4 years from the time of Michael Hardwick's arrest in his bedroom for the case to come up before the U.S. Supreme Court. From the very beginning, the strategy of Hardwick's very capable attorneys, including esteemed attorney Lawrence H. Tribe, professor of constitutional law at Harvard, was to downplay Hardwick's gay identity and frame the case as a matter of the constitutionally protected right to privacy. The Constitution was clear on that matter. People had a right to privacy. The side defending the state of Georgia argued that the Constitution makes no specific mention of any protections for homosexual sex, and that Georgia's sodomy law was a reflection of the moral standards on which this country was founded. On June 30th, 1986, 4 years after Michael Hardwick was arrested in his bedroom, the Supreme Court was ready to announce its verdict. The eyes of the nation were focused on the Supreme Court, and emotions were running high. It was expected that the vote would be close, that the court would ultimately rule against Bowers and Georgia's ancient, cruel, and discriminatory sodomy law. But when the verdict was issued, lo and behold, the unexpected happened. One of the justices, Lewis Powell, was expected to rule against the state of Georgia, changed his mind and instead ruled in favor of Georgia and the constitutionality of its sodomy law. And thus, by a 5-4 vote, the Supreme Court upheld the legitimacy of Georgia's sodomy law and, by extension, the sodomy laws of every state. Oral and anal sex, especially when it involved two people of the same sex, would continue to be crimes subject to punishment, even if it occurred in the privacy of one's own home. How did the majority opinion justify its vote? It did so by selectively making Georgia's sodomy law a homosexual issue, despite the fact that as it was written, it applied to heterosexuals as well as homosexual sex. Justice Byron White, who wrote for the majority opinion, said that the Constitution didn't protect gay sex, thereby making Georgia's law legal. Warren Burger, the Chief Justice, talked about Georgia's sodomy law as virtuously upholding Judeo-Christian moral standards and traditions, which, if you translate it into English, really meant we've always discriminated against homosexuals. Why should we change now? Arguing for the minority opinion, Justice Harry Blackmun said that the issue was indeed one of privacy and condemned the decision strongly, urging the court to reconsider its decision. But of course, the court did not reconsider. And while it is true that over time, there have been few arrests of the kind that occurred with Michael Hardwick, arrested in the privacy of his own home, the very existence of the sodomy law positioned homosexuals as inferior and as presumed criminals. Consider the example of Sharon Bottoms, a 23-year-old lesbian who in 1993 was living in Virginia with her two-year-old son, Tyler. That year, a Virginia lower court ruled that Tyler should be taken from his mother and given to his grandmother to raise because Sharon Bottoms was a lesbian. She took her case to the Virginia Supreme Court and lost. Why? Because of the decision in Bowers versus Hardwick, Virginia's sodomy law was allowed to stay intact, which made Bottoms, by virtue of being a lesbian, a presumed criminal and therefore, according to the Virginia Supreme Court, an unfit parent. 4 years following Bowers versus Hardwick, Lewis Powell, the deciding fifth vote for the majority, was quoted as telling a group of law students that he regretted his decision, saying in a statement that should go down in the annals of understatements, "I think I probably made a mistake in that one." And yet it still took 17 years for the Supreme Court of the United States to finally overturn that mistake. In 2003, in a case known as Lawrence versus Texas, a different Supreme Court overturned Bowers versus Hardwick and declared all sodomy laws in all states unconstitutional. Justice Anthony Kennedy, representing the majority opinion, wrote at the time, "Bowers was not correct when it was decided, and it is not correct today." History remembers Michael Hardwick as an ordinary citizen, caught in a situation that could have happened to any one of us, who found the courage to challenge the forces of oppression. I hope you will remember him too. It was undoubtedly his spirit that pushed the Supreme Court to do the right thing on the day it took the government out of the bedroom. Private, consensual sex between two people of the same sex was no longer a crime. Until next time, this is Dr. Harvey Abrams from the Stonewall National Museum and Archives. Thanks for watching.